Sure. Sounds good. Thanks, Karen. So my name is Matt Bresnahan. I'll jump in first and then provide a little bit of an overview and background about the firm and the topic. And then I'll turn it over to Maysam, who will do a great job walking us through some very important life science patent strategy topics. So my name is Matt Bresnahan. I'm a partner at the firm in our life sciences practice. My specialty is in working with life science companies on patent strategy. So the topics we're going to talk about today of forming a portfolio that protects your product or service on the one hand, and also a very important topic for life science companies of freedom to operate, something that you'll certainly encounter as you go through the financing process. So a little bit about myself. My background is in biochemistry. Before joining the firm, about 15 years ago, I was, even before law school, I was a biochemist, working in various different areas, but a lot of biotechnology focused applications. So naturally I fell into patent law, which I enjoyed very much. I work with quite a number of companies in Southern California. Part of the reason that we're very much happy and thrilled to be partnered with ULP is our focus on Southern California and Orange County. I actually grew up in Orange County, fairly close to Irvine campus there, in San Diego now, and also we spent a lot of time in LA as well. So we're very happy to be here. We do a lot of work with life science companies across the board, from therapeutics, diagnostics, med device, digital health, each area. Myself, I tend to focus a lot with therapeutics and diagnostics and a little bit of med tech and digital health. Some of my colleagues spend more of their time focused exclusively in those areas. As a firm, though, we have deep roots in the life science community. So Maysam, perhaps you could share slide, the first slide. Let me move it over. There we go. Perfect. So recently, something we're very proud of, we were awarded the Venture Capital Firm of the Year for life sciences from LMG. And you know, any given moment, the firm is working on a number of venture capital deals for our clients. Currently, I was on a call this morning with an investor explaining the topics we're going to talk about today. Also have a number of IPOs ongoing right now. A very hot time for the market. A lot of what we do is connect our clients with investors. We host an annual investor forum each year, where we invite about 60 life science VCs to join us, and also solicit one-page executive summaries from clients and friends of the firm, and organizations like ULP and incubators, universities, and requesting that they submit their one-page summaries from interested companies. Last year, I think we had about 450 executive summaries submitted with 60 investors. And then we, in ordinary times, host an in-person forum where companies and investors can meet face-to-face. And typically the investors will spend 2 or 3 days with us at one of our offices around the country, where they'll have anywhere from 8 to 10 meetings with companies, about half-hour to 45-minute meetings. So it's quite nice, something that we definitely like to do and have done on an annual basis now for 5 or 6 years. In addition to that, we have more organic introductions and the like that we're happy to make once we have had a chance to really get to know the company and work with them and get a sense as to what might be a good fit. To the extent we can make an introduction, we do that quite often. We'll go to the next slide, Maysam. Yeah, okay, so just briefly on the topic. So when we think about what is an IP strategy for a life science company, it really boils down to 2 aspects, right? One is creating that portfolio that protects your product or service, whatever it might be, whether it's a small molecule therapeutic, whether it's a new formulation of an approved drug, whether it's a new medical device or a diagnostic platform or a patient selection, companion diagnostic, whatever that might be, to the extent that it's requiring you as a company to invest time, money, and energy, your investors are going to expect that you've created a picket fence, so to speak, around that technology. So we'll talk about that. And then from an investor's perspective, perhaps the most important aspect is really freedom to operate, right? They're going to want to make sure that.
It's not me, it's the other guys, but in case not,
I think somebody might want to go on mute, but I thought that was a question. So FTO is from an investor perspective, perhaps most important. Just as an investor is not going to want to encourage you and invest $5 or $10 million into your business to develop a product or service and then have somebody copy you, they certainly aren't going to want you to spend all that time and energy and money and then get to the market and have a lawsuit against you, right? So we'll talk about FTO, and that's a different consideration than building your patent portfolio. From a company perspective, equally important, and as I mentioned, from an investor perspective, perhaps more important. At this stage of where we're at, typically with working with incubator companies, all these considerations in developing an IP strategy are really designed to help you secure financing and then ultimately enable a clear exit for yourselves, for your early investors, which is what they're going to want to see, and ultimately, hopefully we can help you all bring a really important product or service that's has a huge unmet need to patients. So that's a little bit about myself, the firm, and the topic. And then I'll at this point turn it over to Maysam, who I know will do a great job with all of you. And Maysam, do you want to introduce yourself?
Yeah, hi, and thank you for roping me in here, Matt. My name is Maysam Pessian. I'm an associate. Work closely with Matt down in San Diego, but again, we spend a lot of time up in LA, and I also I live here in Orange County, so I'm around ULP when it's not COVID all the time. I have my background's in immunology, and I try to leverage that technical expertise to assist my clients in securing their technology and making sure that they're not stepping on anyone else's toes at the same time, which is what we'll be discussing today. Real quick, I wanted to thank ULP for having us today and giving me the opportunity to speak to you all. It's really amazing, growing up here in Orange County and seeing something like University Lab Partners here in our own backyard. And I truly hope that over time, more and more people, especially the entrepreneurial community around here, utilizes ULP and its resources to the maximum extent. So as Matt mentioned, we're going to start by looking at how we would secure our own IP and then look at how we can avoid others. Ultimately, the main point I want to get across to everyone today is how does other people's, how does third-party IP affect your goals and what you're trying to do as far as commercialization and innovation. And also, I should be able to see everyone's questions. I don't know if whether I think you can unmute yourself and I can hear your questions, or I can also see questions that you can type up. So I do want this to be as interactive as possible. So please utilize that feature, and I will be stopping at if as questions come up, I do not mind stopping the discussion at all to address those questions. So right off the bat, there are certain requirements to get a patent. I'm not sure how familiar everyone is with these different requirements, but the requirements are subject matter eligibility, novelty, non-obviousness, and then the application has to have enough detail to allow someone reading the claims to be able to practice what's in the claims. The two standards that come up the most and will be the topic of today's discussion are going to be novelty and non-obviousness. Subject matter eligibility is still a hot topic, but generally, especially nowadays, as long as your technology is deemed novel and non-obvious, you're generally able to get a patent on that subject matter. So we'll click over to novelty. So novelty and non-obviousness, they sound like two very similar terms, but they have very specific meanings in patent law. Novelty means one single reference discloses every element of your claim. So as you know, as illustrated on this slide, if the prior art has, you know, parts A, B, C, D, and you're claiming A, B, C, D, then you're going to have a novelty problem. Generally, this isn't too terrible or difficult of a rejection to get around. You can really kind of add a new piece to the puzzle that wasn't disclosed in the prior art, and suddenly you're not in novelty territory anymore. But this is what we call you're opening yourself up to an obviousness rejection. Obviousness means, you know, the examiner can stitch together multiple references to get to the claims that are being examined. And an important thing to consider here is that when we're looking at these prior art references in terms of novelty and non-obviousness, we have to consider the entire reference. So for example, you could be reading, let's say, a Nature publication on some new therapy for cancer. And it has all this data about how this new therapy works great for cancer. We're seeing all these results. And then at the very end, the author might have written something that says, oh, and by the way, this could work for sickle cell disease as well. You know, we think that this could work for sickle cell. They're a cancer company or a cancer lab. They have nothing to do with sickle cell, but just based on their knowledge, they think, oh, okay, this might work. Then let's say there is another reference that talks about the mechanisms, you know, the biological mechanisms of action of sickle cell. And then you come along and try to claim that same therapy for sickle cell disease. You're going to most likely get a rejection based on an obviousness rejection based on those two references, especially if they you know, as long as they came kind of before your application. So how does this all really play out in that situation that I talked about? How do you get over that? Well, how are you going to get a patent if, you know, there's tons of aspirational language out there in journal articles and other patents that say, you know, this could work or that could work. So I picked out a couple patents that I've seen that will illustrate that kind of relationship, and it'll be a perfect segue into issues that arise from freedom to operate. So let's take a look at a patent for a cancer therapy. So, and please don't get I don't know if we have any chemists in the group, but you know, don't get intimidated by any of these molecular formulas. However, this is an issued patent, and the claim reads, you know, a method of treating melanoma comprising, you know, giving this specific compound in combination with nivolumab, wherein the person was previously treated with a PD-L1 checkpoint inhibitor. For anyone that doesn't know, nivolumab and PD-L1 checkpoint inhibitors are both fairly common cancer therapies. So in the process of getting to this issued patent, the examiner cited these two prior art references, a patent application and a journal article. This patent application said, you know, it didn't talk about that exact compound A, but it said that compounds like compound A work for cancer, and they could be combined with other known cancer treatments. Then we have this journal article that had compound A. So just kind of like the hypothetical example I gave you guys, the rejection was something along the lines of, well, if you know that these kind of things can work for cancer and they work in combination to treat cancer, and your specific compound A was already known, then, you know, you putting it all together, it's kind of obvious. You know, we don't think you should be entitled to that patent. So how did these guys get over it? It was their data. They went through the trouble of conducting the experiments and collecting the data to show that this specific combination worked especially well. The way it would play out is, he's an examiner, you know, maybe it's obvious that these things will work together, but it's not obvious that this was, you know, we're getting this significant of an improvement on cancer therapy. And then in light of this data, they were awarded the claim that we saw earlier. So now the applicant, the owner of that patent, has a patent on a method of treating melanoma comprising giving this compound with nivolumab, and where the subject had previously been treated with a PD-L1 inhibitor. So now that they've gone through this trouble of getting the patent and have done the experiments to show that it works, can they start selling combination therapies, or starting to treat people with that patented method? The answer is, unfortunately, not necessarily. So, as separate and distinct from getting the patent, there's what we were referring to as freedom to operate. So we'll revisit this slide, but to illustrate freedom to operate, let me show you this patent. This patent came it's about 10 years before the earlier patent I showed you, and this is an issued claim we're looking at. It says a compound of Formula 1 with all these variables, and then it spells out what each variable can be. Now, I'm not a chemist, so we're just going to kind of fast forward through all this stuff, and you can see it in the public record. But if you put in the right combination of the claimed features, you will get this guy, wherein X2 is fluorine, X3 is hydrogen, and suddenly this is looking, like the compound that we claimed. So this is what we call a blocking patent. It's an issued patent with a claim that covers just this compound. This compound is, you need this compound. Going back to the applicant on the original patent, they need this compound to practice their claimed invention. So, but they can't, if they were to go out and sell their combination or start treating people that had melanoma with that combination, then they're going to be infringing on this patent. They're going to be opening themselves up to a lawsuit. So at that point, what do they do? Well, what's the solution here? We can't, you can't be risky with cancer therapies. With anything, a patent infringement lawsuit can, you might be on the hook for, compensatory damages, royalties. You can even get hit with 3 times damages if the plaintiff can show that you intentionally knew about this patent and you still went about selling your combination. So patent infringement is very, it's something you definitely want to avoid. So we'll get into what happens when you encounter a blocking patent in a sec, but you might be asking yourself, okay, well, how are these people, how is the person able to even research that combination, do those experiments, if this blocking patent was there all along? So our laws allow for a safe harbor. That data figure I showed you guys was something that was submitted to the FDA in their ongoing clinical trials. That under the law, if you're just generating data for FDA clearance or any sort of regulatory approval, you get a safe harbor. So that's how we, logically they were able to get to that step. But as I mentioned, there's this blocking patent in the way. There's several different routes we can take here. There's a lot of different routes. First and foremost, you can license the patent depending on who's the owner. All issued patents, there is a assignment database on the USPTO's website, and you can clearly see who owns the patent, and you can approach the owner and say, hey, I'm interested in taking a license. If it's not one of the big pharma players, then that's a viable option. Big pharma would probably not be so open to that. Another route is you can try to blow the patent up through litigation. prior to 2012, this was a very, very expensive route. We're talking, at least, 5 to 10, maybe even more $1 million. But after 2012, there's a new administrative hearing called inter partes review that can run you somewhere, closer to $1 million, maybe even under, like 800,000. So still very, very expensive. And you can use that to invalidate a patent. Or you can potentially just kind of wait it out. Going back to the case study, they're still in phase 2 clinical trials for that combination. A patent has a term of 20 years from the earliest non-provisional filing. Typically, that plays out is 21 years from the earliest priority date. So going back to our example, this patent's earliest priority date is 2003. Add 21, this thing's going to expire in 2024. If the owner of the first patent doesn't anticipate actually commercializing until after 2024, then that patent's no longer really an issue. It's going to expire. So these are the different kind of routes. And going back, and you might be asking, I kind of glossed over this, but for litigation and inter partes review, I was talking about invalidating a patent. How would you go about that? It really goes back to this kind of process, going back to the examination process. Sometimes things aren't, not every patent or not every prior art reference is cited. The patent office is filled with humans just like you and I, and some things are overlooked, mistakes are made, or perhaps the right references were cited, but the arguments they weren't stitched together properly. So all of this, the screenshot that we're looking at right here, this is all part of the public record. Every aspect of a issued patents process that got to issuance is on the public record. So if you've encountered a blocking patent, you can go and see what arguments were posed against those claims and what did the applicant say in return. And this usually provides the basis for these kind of, for trying to quote unquote blow the patent up. So looking at freedom to operate, I don't know if you guys noticed, but we didn't really concern ourselves with the entire disclosure. We're really only looking at the claims. And the only way you're ever going to have a blocking patent is issued claims. Pending claims don't give you any property right. There's no right you can't exclude someone from practicing an invention with a pending claim. It needs to be an issued claim. So, however, if you come across a pending claim that is, seems like, oh, if this was issued, this could potentially be a problem, then you monitor it. You monitor, as I said, everything is public, and you can see when rejections are issued and when the due date is for the applicant to respond to those. So you can, with every response, the applicant's most likely going to amend the claims. So there's a chance that due to the prior art, or maybe due to their own volition, they amend their claims away from what could be a block to you. So it's always good to kind of to monitor that, keep an eye on that. And it's always good, if you have like known competitors, especially if they're really prolific with their patent filings, it's great to always, monitor their any of their applications that can eventually one day mature into a blocking patent. So I did mention that we're only focusing on the claims. However, when a patent application is pending and you see that the claims, could go in your direction, but you don't know if they will, there is a way, there is a way to kind of determine, what are the possibilities of the directions that this claim can go. And those possibilities are contained in the specification, which is really the rest of the patent application. The claims are the things that are numbered at the very end, and the rest of the application is referred to as the specification. Going back to one of the first requirements for patentability, I said that you must have enough description, detail in your specification that'll allow someone reading the claims to actually practice those claims. That means that your claims need to be supported in that specification. If the specification doesn't have the disclosure on what would be a blocking patent to you if it were to issue, then you don't really have to concern yourself with that application anymore. You could move on to the next one, so to speak. And another little note that I put here is that's very important to consider when you're looking at other people's IP. And this is something that this is an easy one, but there are other kind of similar rules that I would suggest you should consult a patent practitioner when trying to determine, oh, will this be a problem for me or not. But the word comprising, comprising is open-ended. So as we see on the slide there, if you have a claim that says comprising 3 legs, that covers a table that has 4 legs. So going back to the patent I showed you guys, it was a method of treating melanoma comprising administering that compound A with nivolumab, wherein the subject had previously been treated with PD-L1. You can add, you can just add, you can keep saying, if someone were to come around and do that same thing, but then add another step, you're still able to, they're still falling under your claims because your claim said comprising. The opposite of this is the word consisting. If a claim says, a method of treating cancer consisting of these steps, that means those steps represent an exhaustive list. If someone were to add an additional step, it's no longer, you're no longer falling under that consisting of claim. So when you analyze FTO, patentability it's being analyzed all the time as you're going through the process of acquiring your patents. But when do you sit down and actually assess if you're going to stepping on other people's toes? The surefire every answer for every time you for when you it's never quote unquote required by law, but when you really should do it is product launch. There's no safe harbor for product launch, and once you start commercializing, you are making, using, selling, or importing within the United States, and that is the language of the law for patent infringement. So you definitely want to do it at that point. But product launch, we all recognize that especially for startups, that could be well down the line. So the next kind of most frequent time this pops up is fundraising. And do you have to do it all the time? No. Well, when do you do it? Depends on the investor. If I've seen people that depending on the subject matter, they've been able to raise millions of dollars without ever having to do an FTO. Sometimes the investor will be satisfied with whatever examination that goes on in the examination of your own patents. In theory, that examination is supposed to like I said, in theory, the mistakes are made, but it's supposed to show what's already out there. And for some people, that's okay. They'll rely on that. But in most cases, especially when you're talking about 7-8-figure fundraising rounds, more likely than not, you're going to be asked to give a story, give your freedom to operate story. A lot of transactions, and actually we'll skip on to transactions in a moment, but on the fundraising side, if you're not asked to do it, you don't necessarily need to do it. And one of the worst things, not the worst, but one potential problem could be if you're in the middle of a fundraising and no one's been asking you to do it, then by you performing it, you're only potentially kind of hurting yourself. So it's really on a kind of an as needed basis. Moving on to licensing and transactions, it really falls on the licensee slash the buyer. Based on my experience, it's darn near impossible slash very, very tough to get a licensor or a seller to warranty that the product covered in the patents that you're acquiring, or maybe you're just, just getting a license to the actual compound or product. You're never going to get a warranty that says, oh, we're warranting that this thing has freedom to operate. No, you don't have to worry about it, because that is you're putting a lot on the line by stating that. You can usually get something like getting the seller to say, oh, well, there are no blocking patents to our knowledge. And this goes back to the fundraising. You will have to say, in almost all fundraising rounds, you would have to say something like, to my knowledge, I don't know of any blocking patents. And that's why I had just advised, if you haven't been asked to do it and you're already raising funds, in the middle of a fundraising round isn't exactly the best time to do it, because suddenly that to your knowledge question has a different answer, because you've seen the lay of the land. So these are kind of the milestones, the inflection points where you really need to consider kind of conducting this sort of analysis. I kept one slide here. We're nearing towards the end of the broad discussion, and I want to address any specific questions. But since we have time, I want to kind of look into a pending. What is a pending application? A pending claim look like? Pending claims, they can be very broad. When you're looking at a pending application, you're looking at what's called the pre-grant publication of the application. You typically with a patent, you file your priority, your provisional application. A year later, you convert it, and then 6 months from that conversion date, i.e., 18 months from your priority filing date, no matter where that application is in the examination process, that application is going to get published. So it will publish with whatever claims are technically on file at that time. There's a chance that the claims haven't even been examined yet. You haven't gotten an office action. You haven't gotten any rejections. You will get them, but 6 months has passed, and sometimes if you're not fast tracking an application, it can take 1.5 years for the examiner to pick it up. So that's how you see these very broad claims. Let's take a look at this claim. A method for sequencing nucleic acid comprising, so that means the next steps aren't, we're covering the next steps and then some, extending a priming strand of DNA, incorporating a fluorescently labeled nucleotide, and identifying the fluorescently labeled nucleotide. So this is what in the gene sequencing space they call sequencing by synthesis. The priority date for this application for this claim is 2017. A simple Google search of sequencing by synthesis pulled up an article from 2008 describing an exact example of practicing that method. So, if you're doing a freedom to operate analysis and you see this, you're kind of like, well, this is going to block me. It's going to block everyone. What gives? What's going on with this? As I mentioned earlier, this claim doesn't have a property right. It's just a pending claim, and due to based on those 2 bullet points I'm showing you, chances are that's not what it's going to look like when it's issued. The applicant's going to have to amend this claim to get around the prior art. And as I mentioned earlier, you can see what they're going to do because it's all in the public record. So for this particular application, I went on Public Pair, put in the this one actually was not nationalized in the United States, so I went into Europe's register, which is all in English. It's very easy to navigate, and I saw that the applicant had just filed a claim amendment. So now claim 1 looks like this. I'm not going to go through reading that entire claim, but there's some specifics here. It's a lot narrower than this. And so now you can assess, like, okay, maybe that old claim, blocked me along with everyone else, but now there's some more pieces here. There are more pieces of, okay, if I don't do one of these things, then suddenly this application is not a problem anymore. This would be a situation where, we would recommend, if potentially, especially if the specification includes language that could block you in the past, if it were to issue, we would monitor the prosecution of this application, which is periodically we just check in and make sure that the claims kind of stay away from what we're trying to do. So I feel like I kind of fast forwarded through the actual analysis of when you look at a claim to determine if that claim covers your product. So let me go back to this jigsaw puzzle visual. So we had talked about this in terms of getting your own patent, and I said, okay, well, this is an easy one to get around, because if you just add a new piece to the puzzle, then suddenly that piece is not disclosed in the prior art. It's no longer a novelty rejection, which is true. But now let's look at the same situation. Let's look at this visual, but in terms of freedom to operate. If there's an issued patent that has claims A, B, and C, and uses that comprising language, then our strategy of just adding a new piece to the puzzle isn't going to work. That's kind of what was happening in what I showed you guys. This old patent has this molecule. It discloses this molecule. What we did here was we took that molecule and added more pieces to the puzzle. Combination with nivolumab, wherein the subject was previously treated. But as I said, this is still a freedom to operate problem, because we're still practicing everything that was here. So how do you get out of, how are you not subject to that, subject to freedom to operate issue, is instead of adding something, you need to not do just one element of the claim. So if let's say the claim, let's reverse, let's reverse kind of the situation we're looking at. Let's say we're trying to go after someone else, and that someone else, instead of using nivolumab, they actually use a different checkpoint inhibitor. Suddenly, that they're no longer exposed to being sued or they're no longer exposed to infringing this patent, because we had to specifically claim nivolumab. So with all this, considering all this information, this is why it's very important. This is why the name of the game, so to speak, is to get claims that are as broad as possible, because you want to protect as much as you can. Going back to this patent, not only are they protecting this specifically compound A, but they're protecting all these different combinations. How do you get a patent like this? There has to not be prior art. Why did we have to add nivolumab? Why did we have to add wherein the subject was previously treated? Because that was all obvious based on the prior art. If you're the first mover, then you're going to be you're going to be entitled to more coverage, broader coverage, and that's going to present more FTO issues for the people that come down the road / your competitors. So that really covers the slides that I prepared, and I would really like to answer any kind of specific questions that might arise. I feel like we kind of just covered a lot of different information here, a lot of different moving parts. So please, don't be shy about asking. And if nothing comes to mind right now, I'm very accessible, both at ULP or just at my own home. Shoot me an email, shoot me a call. and I'd be happy to discuss any of what we talked about in greater detail.
Great. Thank you so much, Maysam and Matt. Any questions? Please jump on your mic. You guys all have open mic abilities here. So if you have any questions, you can go ahead and unmute and engage in a conversation. Let's see, because we have a few more minutes. Anyone? Let's see here. Mason, we did have some questions that came over email for attendees. So one of the questions is, I'm looking for a claim that's very, very broad, pretty much covers the entire field. How do I get around this?
Okay, well, first, right off the bat, I would revert to what we kind of talked about in regards to pending claims. If it's very broad, let's assess to see if it's actually an issued claim. Really quick way for anyone to determine if it's issued or pending is look at that serial number. Issued claims are going to be, in this day and age, they're going to be starting at 7 million, 8 million, 9 million, and 10 million. So if you see a number, if you see the serial number in, being a 7 million or 8 million, 10 million number, that'll indicate to you that it's actually an issued claim. However, if you see a serial number that starts with a date, like so, then that would indicate that it's a pending claim. So if it's a pending claim, again, you're okay for now. We just need to monitor it. If, in fact, it is an issued claim, then we got to revert back to this slide over here. We have options: the license, the litigation, waiting it out till expiration. Those are your options. However, an important thing to kind of consider is if a claim issued that is that broad, the broader a claim is, the more relevant prior art there is. So what you need to do is either pay a practitioner or just kind of click around. Click around the art, see if there's anything out there that wasn't considered. You can go, like I said, it's all public record. You can go and see what references were considered and how were they considered. If you can use your technical expert and see if those arguments make sense. See if there's a better argument that from the art pieces that were used. These are all different ways you can kind of prepare. And depending on where you are as far as business development, if we're at product launch, then we're gonna need to either take the license or blow it up. But if you're, let's say, at fundraising, perhaps you can just you only need to get as far as preparing your art positions, and that will give certain investors enough confidence to say, okay, this might not even be a problem, but if it is, they're showing to me that they have a plan. They have their references ready, and that this will the chances are the patent owner doesn't want to get their patent invalidated. So that could there could be alternative dispute resolution and things of that nature. And a little off topic, but it's kind of a nice, what I just said is a nice segue, is, you have this, if you have a broad claim, you have more prior art that is subject to that claim. So when you're drafting your own patent, you got to kind of think about that too, more of a defensive measure. So what I typically recommend is, you definitely want to go for as broad as possible, so you're blocking as many people as possible. But you also want to you also want to hit those narrow points in the form of dependent claims or maybe even a separate independent claim. Because in patents, if you get, you don't invalidate an entire patent, you invalidate claims. So if you have a very, broad independent claim, something like this, and then you have dependent claims that are like, oh, well, the method of claim 1 wherein, the fluorescently labeled nucleotide is some very specific, compound A that you developed, you want to make sure you mention that, because maybe claim 1 gets invalidated, but there is no art to invalidate your novel compound. So in that situation, the courts will invalidate claim 1, and then they'll rewrite claim 9 or whatever, the claim that you have your novel compound in independent form. So you're still able to, you still have a patent. If you're licensing that patent to other people, you're still able to collect royalties on it. You're just you don't have that property right for the broader claim. So that's another kind of thing to really think about as far as judging, broad versus narrow.
Great, thank you. Now, as part of the patent process, does your patent get searched against prior art? And if so, does the examiner find potential blocking patents for you?
That's a great question. In theory, yes. In theory, yes. Whenever we're doing a prior art, an FTO analysis, especially if there was a, especially if there was a 102, if there was a 102 rejection against your own patent, indicating that one single reference is pretty close, and especially if that 102 is an actual patent, then that is going to be the first place we look to see, is there a blocking patent there? So in theory, yes. But let's go back to this case. First of all, I said that the patent office is filled with humans too. Things slip through the cracks. But also, it's important to note that once this non-patent literature was brought on to say, okay, this compound A, exists in the art. People know about it. The examiner's not on the hook to pull up every single reference that talks about this compound. If they just show one reference that is prior art to your claim, that's all their analysis their search can stop right there. They're not on, they don't, that's why in this situation, you might ask yourself, okay, they only came up with these two, but this one was from 2003. This is relevant to that claim. Why wasn't this patent brought up in the prosecution history or in the examination process? Because the only reason you would bring in this patent is to show, like, hey, this patent says this compound's already there. These guys are trying to get this compound, then there's a problem here. But here, this non-patent literature article says the same exact thing. And also it didn't require the examiner to do all that chemistry hurdling to make sure that, oh, if you align the variables just right, you get compound A. This journal article just flat out had it there, published. Here's compound A. So the examiner's not on the hook to go find all that. So that's why it's a separate analysis. That's why it's a completely separate kind of thing, really. Again, you can rely on the search process, the searching of patent offices. Some investors rely on that, especially if you're very early onto the scene. Then there's even more. You can have more kind of confidence in those kind of searches. But especially in a crowded space, there can be a whole world of references and patents that were never cited in the actual examination process because they're very similar to stuff that was cited. And that this concept kind of goes both ways, going back into invalidating patents. Just because a patent got okayed by the office doesn't mean all the art was considered. Maybe there's an art piece that wasn't considered because it was very close to something that was considered. But if you actually read that thing cover to cover, there are certain disclosures that would actually make that reference a better obviousness combination than what was actually considered. And that would be perfect grounds for, in invalidity position.